We're up to 32 participants now. We're going to wait for just a couple of more minutes. I dearly love us to get to 35 and we'll get started.
Mm-hmm. All right, I think we can start. And as more people come in and trickle, they can come in. And yeah. Hi everyone, my name is Abdulrahman Mohammed. Yeah, so today we'll be having our presentation by Mr. Wilkinson and Mr. Mueller. And a little background for me, I'm a youth representative on the HERO Commission, which stands for the Human Rights and Equal Economic Opportunity. I've been with this commission since last October for the Youth on Boards Initiative. And yeah, I'll just be doing the introduction. So we have Mr. Mueller, who is an attorney at the Southern Minnesota Regional Legal Service with a specialty in human rights and housing. And as for Mr. Wilkinson, he's also HERO Commissioner and former fair housing lawyer with Legal Aid in Minneapolis. They'll be leading the presentation and answering any of your questions at the end of the session. And I would like to formally shout out our sponsors, the HERO Commission, the Southern Minnesota Regional Legal Service, the Volunteer Lawyer Network, as well as the National Alliance on Mental Illness of Ramsey County. And today our presentation will cover legal rights of those with disabilities, to changes in the housing rules and practices, and to modifications in buildings, how to effectively request those changes, and what to do if these changes are denied and relief available, and the relief available when rights are denied. I'll pass it on to Mr. Mueller for his presentation.
Hey, good afternoon, everybody. Let's see, I'm not able to see if my screen was shared. Let's see, but I can't see
It is
any
not.
faces. So now it's not. Let me see. Let me go back to sharing it. Yeah, but I can hear voices. That's good. So that means that you can confirm whether or not it's being shared. Okay. Well, I guess I'm going to have to live with not seeing any faces. And Bridget, I'm not able to see the screen if questions are directed in. So, I mean, if you think it's appropriate and necessary, feel free to let me know. Okay, I'll try to fly a little bit blindly on that, and we can roll with it. Good afternoon, everybody. My name is Thomas Mueller. I'm a housing attorney at Southern Minnesota Regional Legal Services. I'm really happy to have the opportunity to share today regarding, you see on the screen in front of you, reasonable accommodation modification requests under the FHA and MHRA. I try as hard as I can to not use acronyms unless they've been defined. And of course I did that on the first screen, but the FHA is the Fair Housing Act. That's a federal law that applies.
Mueller, sorry to interrupt, but we don't see the screen.
You don't see it? You don't see the screen?
Yeah, please try one more time to try present it.
Okay.
You've got your smiling face.
Well, there you go. I don't even have that. I just have the PowerPoint, so I don't understand. Let me try again. So do it from the beginning here. Did it come through that time or no? Do I need to hit something else?
No.
Okay, so let me try slideshow. Let's try that. Did that come through?
Yeah,
okay.
We can see it.
Okay, great. Let's see. Okay, well, now I've got the slideshow up but I can't see any faces again. So Bridget, same thing. I don't know if I'm going to be able to see any questions if they come in, but I'll go from there. Okay, so on this first screen, you see going to talk about reasonable accommodation modification requests under the FHA. So that's the Fair Housing Act. That's a federal law, obviously applies nationally, and it covers a large percentage of all the tenancies, the rental units in the country. And the MHRA, so the MHRA is the Minnesota Human Rights Act, and the MHRA extends to some degree, and adds a little bit of law that can be valuable as well in Minnesota. On the last percentage, about third of the presentation, I'm going to talk about reasonable accommodation requests for service or support animals, emotional support animals. And my goal today is to share in a way that hopefully will give a very good introduction to what you need to do in order to request a reasonable accommodation or a reasonable modification, and to give you an idea of what would likely qualify you for that, and what a landlord may be able to say in response, and what the landlord's responsibilities are. So we'll go from there. Did the second slide pop up, or do I need to do something
Yes.
else to get it? Okay, great. Okay, so the first thing I want to do is just explain in general what rental properties are covered by the FHA and the MHRA. And the short answer is that basically almost all rental properties are covered under these laws. So that's good, because these laws provide the legal backing for requesting a reasonable accommodation for a person. HUD, so the Department of Housing and Urban Development, provides guidance on exactly what's covered. And what I tried to do in this slideshow is I tried to make it as user-friendly as possible if you want to request a copy. So we can make a copy available. I tried to provide the links to pretty much all the places where you can find this information in the future and additional reading. And I also, cited to the statutes, the guidance, or the law. So in this case, HUD guidance provides that the FHA, the Fair Housing Act, covers most housing. In very limited circumstances, the act exempts owner-occupied buildings, but those are very, very limited. So no more than 4 units, single-family houses sold or rented by the owner without the use of an agent. You get the idea that it's a very, very specified exemption. So nearly all rental properties are covered. Now, the MHRA, the thing that you should know about that is that it provides exemptions for even fewer types of properties. And again, you're getting into pretty fine details at that point, which probably we don't have to go into those details today. But I say that just on the off chance that if a property isn't covered by HUD, it isn't covered under the Fair Housing Act, the FHA, you may want to look into whether or not your client could be covered by the protections in the MHRA. Going to slide 3. Okay, so I want to just kind of give you again, this is kind of the broad overview at this point. The Fair Housing Act in general, and this is what I'm going to cover for the next few slides, the first about quarter of this presentation. The Fair Housing Act in general states the following. It'll be unlawful. It says a lot of different things, but this is one of the parts of it. It shall be unlawful to represent to any person because of race, color, religion, sex, handicap, familial status, or national origin, that any dwelling is not available for inspection, sale, or rental when it is in fact available. I've dealt with this particular issue. I've had landlords who have indicated that, it seemed as though, I mean, you want to assume good intentions, but it seemed as though they did not want to make available a unit that might have been potentially been inhabited by a person with a disability. So this is absolutely something that that you may see or perhaps have already encountered. Continuing on, the Fair Housing Act states that it shall be unlawful to discriminate against any person in the terms, conditions, or privileges of sale or rental of a dwelling, or in the provision of services or facilities in connection with such dwelling because of a handicap of either that person, A, or a person residing in or intending to reside in that dwelling after it's sold, rented, or made available, or to any person associated with that person. And that's really key. So it doesn't just have to be the lease signer. Any person, it could be the lease signer, but it could be a person intending to reside, or it could be a person associated with that person. That's very key as well. So there's a difference between reasonable modifications and reasonable accommodations. So I want to just briefly touch on that and go over that for us. So the Fair Housing Act, with regard to reasonable modifications, states the following. It says, for purposes of this subsection, discrimination includes a refusal to permit at the expense of the handicapped person reasonable modifications of existing premises occupied or to be occupied by such person, if those modifications are necessary to afford them full enjoyment of the premises. Except that, again, there's an exception written right into the statute. In the case of a rental, the landlord may, where it's reasonable to do so, condition permission for modification on the renter agreeing to restore the interior of the premises to the condition that existed before the modification, reasonable wear and tear accepted. So you may have to put it back. Now, a couple things that I probably want to emphasize about these reasonable modifications is that you'll notice that it says at the expense of the handicapped person. So that's really key. Like if you are requesting a reasonable modification, that's something you want to be aware of. So a reasonable modification is, a change to the conditions, the structural essence of the property in a way that would make it equitable. In this case, when you request that, you do have to take into consideration what it may cost you. So you may have it granted, the opportunity to do that, but you would have to pay for that. And at the same time, you may have to restore it to the condition that existed before the modification. So those are really important things to keep in mind. Now, with regard to reasonable accommodations under the FHA, that for purposes of this subsection, discrimination includes a refusal to make reasonable accommodations in rules, policies, practices, or services when such accommodations may be necessary to afford a person equal opportunity to enjoy a dwelling. So you notice the difference when we're talking about reasonable modifications. We're talking about kind of the structural integrity of the building, talking about things like being added or changed, like that are actual things in general. You can think of it that way. When we're talking about reasonable accommodations, you notice in line 3, we're talking about rules, policies, practices, or services. And so that's kind of a huge difference. And when you hear different terms, you're going to be thinking about slightly different things. Okay, so you'll notice that in the FHA, they use the word handicap when talking about persons with disabilities. They do define that, and I think that's really important to know and to look at and to know exactly what they're talking about. So so they define it in that same section. It's I've tried to keep a reference to the statutes that are involved here. In this case, 42 USC section 3602 is where the definitions are. So handicap means, and these are really key because if you key to spend some time thinking about and understanding exactly what's referred to and what's not referred to. So handicap refers with respect to a person to a physical or mental impairment which substantially limits one or more of such person's major life activities, or 2, a record of having such impairment, or 3, being regarded as having such an impairment. All of those things, they're ors, not ands, which means you don't have to have all 3 of those. You just have to have one of them. And that qualifies you as a person with a handicap under, and entitled to the rights under the Fair Housing Act. Now, I want to highlight the note at the bottom of that. So underneath number 3, you see note. Handicap does not include current illegal use of or addiction to a controlled substance. It also does not include juvenile offenders or sex offenders. And so that's really key. Like those are the types of things you're going to want to discern when you're talking with your clients. If that's the types of things they're talking about, is that actually what they're requesting a reasonable accommodation for, or is it something other? But that's really key. So when we think about physical or mental impairment, if I go back, we look at number 1, physical or mental impairment, substantially limiting life, one or more of a major life activities. When we talk about physical or mental impairment, HUD provides guidance on that as well. So physical or mental impairment includes, but is not limited to, diseases and conditions such as, and these are just a list of things that would qualify, but it's not an exhaustive list, such as orthopedic, visual, speech and hearing impairments, cerebral palsy, autism, epilepsy, muscular dystrophy, multiple sclerosis. So they're listing very specific things. And you'll notice at the end, they also list drug addiction. And then they talk about that it's other than addiction caused by current illegal use of a controlled substance. But if it was not current, or if it was not an illegal use of a controlled substance, then it would qualify. And alcoholism. Similarly, we're talking about physical or mental impairment that impairs or limits one or more major life activities. So major life activities, we have to ask what those are as well in order to be qualified for protection under the Fair Housing Act. Major life activities include, but are not limited to, seeing, hearing, walking, breathing, performing manual tasks, caring for oneself, learning, speaking, and working. Again, that's from that HUD guidance. In my experience of requesting reasonable accommodations for my clients, I've yet to find a case where a person has, a disability that doesn't fall under one of these major life activities. For persons who are saying that they have a disability, and so it's really broad. And again, that's not an exhaustive list. But it does cover an extremely broad range of things. So when we talk about, again, just want to specify a very specific point now. Like, what does it mean for a person having been regarded to have such an impairment? Do they actually have to have a specified disability? And the answer to that is no. And it kind of pokes its head out in ways like the following. So a person can be regarded as having a disability, even though they may not have an impairment, or they may have an impairment, but it doesn't affect one or more major life activities. And here's an example. So a landlord might refuse to rent to a tenant that they believe has a disability. And that would be in violation of the FHA, even if that person was found to not have that. And so landlords are held to a high standard in that regard. Now I'm going to transition slightly to the Minnesota Human Rights Act. And I'm just going to kind of highlight some of the differences, but also just a little bit of that law so that, we can be on a general footing in that regard. So the Minnesota Human Rights Act, which is codified at, 363A. I don't know if you know this or not, but Minnesota laws and federal laws in the era of the internet, which we've been in for decades now, they're incredibly easy to find. If you just put in 363A into a Google search, you're likely to, it'll be the first thing coming up. And the statutes are organized in a way that's very easy to read through them. Usually starts with definitions and then provides, what the protections are and your remedies, etc. But if you can always just search for these statutes through Google. So the Minnesota Human Rights Act, I just wanted to highlight it, the first part, that in addition to protecting persons with disabilities, they also protect a broader range of individuals than those that are protected by the FHA. So these include a person's creed, or marital status, sexual orientation, or status with regard to public assistance. That may not be directly applicable to the conversation today. However, I think it's really important to know and to have a general idea that sometimes persons will come to you, and obviously, there's a broad range of needs for people and our clients. And so they may be protected under a Minnesota statute, even though they may not necessarily be protected in terms of that characterization or that category under the federal statute. Okay, so this is how the Minnesota Human Rights Act, the MHRA, talks about discrimination generally and your protections for persons with disabilities. So it's an unfair discriminatory practice for an owner, lessee, etc. They list multiple other categories to discriminate, and that also includes agents, so agents of the owners, or to discriminate against any person or group of persons because of race, color, creed, religion, national origin, sex, marital status, blah, 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 disability in the terms, conditions, and privileges of the sale, rental, or lease of any real property, or in the furnishing of facilities or services in connection therewith. And then they provide an exception, because statutes love to do that, except that nothing in this clause shall be construed to prohibit the adoption of reasonable rules intended to protect the safety of minors in their use of the real property or any facilities or services established in connection. So you'll notice that it's very similar. The FHA and the MHRA are not perfect mirrors of each other, but they are very, very similar and ultimately end up protecting a lot of the same things. The Minnesota Human Rights Act, MHRA, also defines disability, and you'll notice that it's a very similar, albeit not a perfect mirror of the definition in the FHA. So disability under the Minnesota law means a condition or a characteristic that renders a person a disabled person. Disabled persons, any person who has a physical, sensory, or mental impairment that materially limits one or more major life activities. A person who has a record of such an impairment, or 3, again, is regarded as having such an impairment. One of the differences, for example, in this definition versus the FHA's is you'll notice under number 1 that they talk about an impairment which materially limits one or more major life activities. In the FHA, that language is substantially limits. And so, that's kind of a small, but kind of could potentially be a legally important distinction. Just in general, okay, so we're at a point where we know that these laws say you basically can't discriminate, that you have to provide a reasonable accommodation. But what are things that would constitute illegal conduct? So these are just a brief list, and we're going to talk about other things. We're going to talk about any questions that you might have as well. But illegal conduct might be simply a refusal to rent, or it could be purchased, but at least at Smurls, at Southern Minnesota Regional Legal Services, we're talking about almost always tenants. There could be differential terms or conditions of rental. You would have to pay extra if you demand, or if you need some sort of accommodation. That would be illegal. Or there might be a refusal to grant a reasonable accommodation. So if you request one, and we're going to talk about how you do that in a little bit, but if you request one, if a landlord refuses to grant that, that's an illegal action. Similarly, if you request one, but then your landlord takes retaliatory action against you, that's also illegal. So you have a right not only to request, a reasonable accommodation or a reasonable modification, but you have a right to not have your landlord ultimately use that against you in some sort of punitive way, perhaps through the ending of your subsidy, or through an eviction filing, or things like that. Okay, so again, what is a reasonable accommodation? I kind of talked about this earlier, but it bears repeating, especially as we think about, like, how do we ask for this? So what is it? It's a change in rules, policies, or practices where the accommodation is necessary to afford an individual with a disability equal opportunity to use and enjoy a dwelling. And if a reasonable accommodation is requested and not granted, that, if it's not, there are reasons it may be denied, but if those aren't met, then that's a form of disability discrimination. Okay, so here we get into a little bit of the nuts and bolts of how do you do that. It's generally quite simple, honestly. You don't have to have a law degree. You don't have to know all the legalese of how to say this perfectly. There's not a perfect way to say it, is the short answer. But there are some things that you want to make sure that are part of any sort of reasonable accommodation request. Number one, and this is obviously really key. So the accommodation or the modification, it has to be linked to a disability related need. So in other words, there has to be an identifiable relationship. Sometimes landlords or housing agencies will talk about a nexus, just a clear relationship between the requested accommodation and the individual's disability. So I guess I'm trying to think of an example off the top of my head. If someone had a need for, if a person had some sort of disability that caused them to be extremely lethargic, for example, but the issue, in fact, in their housing, and the dispute arising between them and their landlord was not something that was affected by tiredness, then a reasonable accommodation, even though that person has a disability, they wouldn't be entitled to that. And so that's really key. That's going to be the first thing you're going to want to look at when you're talking with tenants. Is there a connection between the issue that's in dispute between the landlord and the tenant and the disability that your client has told you about? I would say worth noting as well in this particular thing is at this particular time is that sometimes I've spoken with many people who I asked them, they're saying that they were unable to do certain things that are demanded by their landlord, and that's affecting them. And I'll start talking to them about whether or not there's a disability involved, and they'll start telling me about, that they saw a psychologist or they saw a doctor, and they were diagnosed with this or this, and it's not related at all. But then 10 minutes later, we're talking about other things. And they'll tell me about depression, or they'll tell me about post-traumatic stress. That's also been a part of their life that they've also talked to medical professionals about. And those things then are directly related, even though the things that we had talked about earlier aren't. And so sometimes it's definitely worth kind of digging in a little bit and trying to figure out, you know, do you have a complete picture of exactly what's going on in your client's life? And sometimes that can be very valuable. So there's got to be this nexus. There's got to be this link between those things. The second thing is when you're requesting a reasonable accommodation, again, it has to be necessary to afford an equal opportunity to use and enjoy housing. So it obviously has to go towards something that any other tenant would be able to enjoy at that housing. And the third thing, it has to be possible to implement. I'm going to hold off on talking about that third item right now, but I'll get to it in short order. Okay, so as I said, it's unlawful for landlords to refuse reasonable accommodations or modification requests. So the Department of Housing and Urban Development and the Department of Justice put out a statement. I believe that's included in the materials that we've put together for you today. But it's also really easy to find if you just search for that that kind of link at the bottom of this slide. You can find it really easily. It's all available online. But anyway, the Department of Justice and HUD both, you know, they put out this statement. It's unlawful under the Federal Housing Act for a landlord to refuse to grant a reasonable accommodation when the accommodation or modification is necessary for a person to have equal opportunity to use or enjoy the dwelling. And that includes public and common use spaces. And that's an important part. That's why I put this slide in here, because it's not just about being able to use your room or your bathroom or your kitchen. You have, as a person with a disability, persons with disabilities have equal right to use and enjoy the public and common space as well. And that's really key. So a reasonable accommodation request or a reasonable modification request may be about the common space. Okay, so this slide, treating different tenants differently. I've been in this conversation with many landlords where they say that first bullet point, that it would seem reasonable to them that an RA, a reasonable accommodation request, could be denied. They want to deny it because they say, look, we don't want to, if we grant it, then that means we're treating a tenant with disabilities and a tenant without disabilities unequally. But what you have to remember, and this is, again, this is straight from the joint statement of HUD and the Department of Justice, accommodations by their very nature are changes, exceptions, or adjustments. Okay, so they are changing, they are treating people differently. That's what a reasonable accommodation is asking for, to rules and policies or practices or services that are necessary for persons with disabilities to have an equal opportunity to use and enjoy the tenancy. That's the key. So you change the policy, you change the rule, you change the practice so that the opportunity to use and enjoy the residency is equal. That's the key. And thus, and this is the key part, this kind of the explanation, treating persons with disabilities exactly the same as others and may sometimes deny them an equal opportunity to use or enjoy the dwelling. So that's a really key element of this, that essentially what you're saying is, or what you're doing when you request a reasonable accommodation, is you're saying the policies and practices need to be different in order for the equal opportunity to exist. And that's really key, because sometimes you'll find yourself in a conversation with landlords where they're saying, we can't do that. That would be illegal for us to treat people differently. Well,
Com, I'm going to interrupt here.
Yeah, please.
we can answer the first question that was posted a while back, and that was just to give an example of what a reasonable accommodation is. And I'll just say that it would be unequal for a landlord that has a no animals policy in their apartment building to allow a person with a seeing eye dog to live there. It is unequal. No other person would be allowed to have a dog in their apartment. That's correct. But it is required by law unless there is some very good reason for them to deny a person that needs a seeing eye dog to live there. So it is unequal treatment with the goal of having that person with a seeing eye dog be able to navigate and live in an apartment that they wouldn't otherwise be able to live and enjoy, to have equal enjoyment of without having a change in that policy. So that's to make concrete what a reasonable accommodation is. And you can think about the rest of the program along those lines as we get going. So now that I've given you, had you take a break, you can continue. I thought that would be a good way to answer that first question.
Yeah, thank you, Jay, for that. I think that's excellent. And for some reason, I'm not able to see the chat. So unfortunately, if there's other questions that come in, feel free to jump in. Kind of running a little bit blind on that, but yeah, thank you, Jay. So that's key. That's key. You are asking, in a sense, for different treatment, and that's not only legal; it's your right. Okay, so landlord defenses. Now this is really key because amazingly enough, and I think it's really true. Like the longer that I practice law, the more I'm struck by the fact of how powerful requesting a reasonable accommodation is, because there is a legal obligation on the part of landlords really to grant them. Like if you request one, if you're a person with a disability, if it's connected to the equal use and enjoyment of the premises, if if you're entitled to one, you really are legally entitled to one. And that's very powerful. That's a lot of power that you have. So that being said, it's important to know that there are limited occasions when they can be denied. And so it's important to know these from the get-go and know how that works. The first bullet there is that your tenant might not fall under the definition of a disability. Okay, so that's possible. I think, I think the number one thing that you want to do is, in order to, you don't have to do this, but it's really helpful, is confirm a person's disability through a medical provider of some sort. If there's a question about whether or not they fall under a disability, the easiest thing to do is have, one of their doctors, their primary, their counselor, their psychologist, whatever it may be, get their medical records that would indicate that. And obviously you want to look for the things that are a nexus, that are related to the accommodation that's being requested or the accommodation that's needed. The next three, I'm going to talk about in a little bit more detail. So a landlord can deny a reasonable accommodation request if they say that it imposes an administrative and financial burden that's too great, that's undue is the language. Okay, so and HUD guidance provides that the determination of undue financial and administrative burden has to be made on a case-by-case basis. So first of all, if they're just saying, oh yeah, we've talked about that issue in the past, and we think that's not reasonable, that's probably not going to be sufficient as a legal reason to deny a reasonable accommodation. It has to be a decision made on a case-by-case basis. You're going to look at the following factors. You're going to look at the cost of the requested accommodation. For example, I've worked with clients who are requesting that that they're allergic to certain chemicals, and their allergies are significant and potentially even life-threatening in at least one case that I worked with. And they're requesting that the landlord change the chemicals in their cleaning agencies that they're using. It's almost certain that changing the chemicals that are being used to something else is not going to be cost prohibitive. So, but if you're looking at other types of accommodations, it may be, and that would be something to figure out, especially, maybe if it's involving retrofitting, or that would be a bad example because that'd be a modification. But if they were asking for a modification and there's, well, I digress on that because that's a different topic. Regardless, they're going to look at the cost as one of the factors in whether there's an undue financial burden. They're also going to look at the financial resources of the provider. So that's key. I mean, some organizations, some landlords have far more resources than others. They're going to look at the benefits that the accommodation would provide to the requester. So there's going to be kind of like a weighing. Like if we change this and it costs a certain amount, but it ultimately doesn't provide much benefit, then that might be something to look into and balance. And relatedly, they're going to look into the availability of alternative accommodations that would effectively meet the requester's needs. So if there's, the reasonable accommodation might specify, this is what I need to happen in order to resolve this particular issue. The landlord may say, hey, we've actually worked with that before, and this is how we resolved it. And they might suggest that. So in that interactive dialogue that's going to happen anytime you make a reasonable accommodation request, that might be one of the things that's thrown out there. The third thing is that there might be a fundamental alteration of the landlord's business practices. And if that's the case, it might, that's a basis to deny a reasonable accommodation request. So, but here's the thing, that if a landlord, if a housing provider refuses a requested accommodation because of fundamental alteration, they would have to, the provider should discuss with the requester. So if you're making this request, they should discuss with you whether there's an alternative accommodation that would effectively address the disability related need without a fundamental alteration. So it's not just like, well, that would fundamentally alter our business practices. It would cause us to go from being a tenancy, a housing opportunity that's maybe generally related to all, to a completely different type of thing. It would cause us to be, I don't know what they might say. They might say it would be, all of a sudden it would be like a group home type of situation. They might say something like that. But what they would need to come back to is you would need to talk about if there's a way to provide an accommodation that would actually not be a fundamental alteration to the practices. If an alternative accommodation can effectively meet your request for a disability related need, and it's reasonable, the provider must grant it. That's really key. And here's the key, is that an interactive process in which the housing provider and the requester discuss the requester's disability related need with the requested accommodation and possible other accommodations, alternative, is helpful because it results in effective accommodation for the requester, but it doesn't impose an undue financial burden. That's the key. So we're trying to figure out, what's going to work. The last way that a housing agency, a landlord, a housing provider might be able to deny A reasonable accommodation is if there is a direct threat to health and safety that cannot be eliminated or significantly reduced through an accommodation. So now, again, the key on this is you're going to hear this language. Well, that person we're evicting them. We're evicting them because they're posing a direct threat. They're going to use that language, a direct threat to other residents. Because of perhaps they assaulted somebody, perhaps they brought an illegal weapon onto the property, perhaps they used language that was allegedly threatening. What you're going to want to do, what's going to be key, is that in each case, and this is really, really fact dependent, you're going to want to really figure out exactly what's happened, what's going on. But you have to make, and the landlord will have to make, an individualized assessment. So that's key. It's going to be case by case. And number two is it has to be based on reliable, objective evidence. Okay, so it can't be, hearsay might count when they're talking about threats. So it's not about that. It's not like a judicial level of evidence, but it is based on, there has to be something that's actually going on that's reliable and objective. Okay, so that when you're looking at this consideration, whether or not your client poses a direct threat that is causing the landlord to say we're not going to accommodate their disability, you're going to consider the nature, the duration, and the severity of the risk of injury. Obviously, there's a big difference between the use of weapons, whether, and the types of weapons, right? So you're going to look at that. Does the tenant still have a weapon? You might consider that. You're going to look at the probability that the injury will actually occur. So maybe your client does own a weapon of some sort, but they don't have it in the state, so you consider things like that. And then you're going to consider whether or not, and this is going to be the key, and this is where you really have to we have to put on our thinking caps and try to figure out how to be problem solvers, is whether or not a reasonable accommodation is going to eliminate or significantly reduce that threat. If your client is willing to go to counseling, is that going to significantly reduce the threat? And it certainly may. You may be able to get a statement from a counselor or a psychologist or a doctor that if they take their medication that's being prescribed, or if they go to counseling, that will reduce the threat. And maybe there's even historical evidence to that effect, such as they were not on their medication when an incident happened, but they have been for the past 5 years. It was an unfortunate circumstance that resulted in not being on their medication. And so now they're back on it, and that's going to reduce the threat. So even if there are some of these defenses to not providing a reasonable accommodation, that's not the end of the conversation. That's what I want you to know and hear and remember from this slide, because I think this is a really important one. You're going to remember that this is an interactive process, and you're going to keep bringing the discussion back to, can we find an alternative way? Can we reduce the threat? Can we reduce the cost? And can we keep you as a landlord or as a housing provider and not fundamentally change your business? So that's going to be really key. Okay, so in the last year, in 2021, there was some significant changes to reasonable accommodations as are part of service animals and emotional support animals. I want to go over a little bit of those changes. I want to talk about kind of as an example, in general, like what does it look like to request a reasonable accommodation such that a person can have a service animal or an emotional support animal. So we'll get into that. Okay, so the first thing again is definitions are really key here. I've got a slide that's coming up and it's going to say this, but I want to say it here. is that the key to remember in legalese and in truth is that assistance animals, service, emotional support animals are not pets. That's really key. And so, so if you're talking about that, if you're, with a landlord or a housing provider, if you're, talking about whether or not this animal can be a part of that household, and as a needed thing because of a disability, then you're not going to ever want to use the word pet because it's not a pet. And there's a lot of big legal differences in that regard. So this slide, I know it's got a lot of words and it's probably a little bit too busy, but it's helpful and you might want to refer back to it in the future. So HUD, again, the Federal Housing Agency, is providing a definition that an assistance animal, they kind of group this a little bit together, is an animal that works, provides assistance, or performs tasks for the benefits of a person with a disability, or that provides emotional support that alleviates one or more identified effects of a person's disability. And they're explicit, an assistance animal is not a pet. In Minnesota, we break them down a little bit more. So service and support animals. So a service animal for Minnesota means a dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including physical, sensory, psychiatric, intellectual, or other mental disability. Other species of animals, whether wild or domestic, trained or untrained, are not service animals for the purposes of this definition. And then I sorry for the typo, but emotional support animals, a support animal means an animal that provides emotional support that alleviates one or more identified symptoms or effects of a person's disability and doesn't need to be trained or perform a specific disability related task. You can request a reasonable accommodation for service animals or support animals, but they are very different. And that's a really key distinction to know. Okay, so again, I said I was going to repeat myself a little bit here. An emotional support animal is not a pet, and it's also not a service animal. There's 3 separate categories. A service animal is any dog individually trained to do work. And again, that's just a repeat, but I want to highlight that really clear because the language that we're using when we're requesting an accommodation with regard to animals, whether support or service, is really key. And again, that's just a repeat of the other, that a support animal provides emotional support and it doesn't need to be trained. So that's really key. Okay, so trying to get a little bit of our feet on the ground, like what does this mean exactly? Okay, so animals that are commonly kept in households. So it's a dog, cat, small bird, rabbits, hamsters, gerbils, fish, rodents, turtles, other domesticated animals that are kept in the home for pleasure traditionally, rather than for commercial purposes. And the reasonable accommodation should be granted if the requester has provided information confirming there's a disability related need for the animal. Okay, so that's the way it works. Hopefully I'm being clear here and this is making sense, but what's happening is a person has some sort of disability. Many of the clients I've worked with have anxiety or depression. So that's a mental health disability, right? And they have a dog that might, have a connection to that disability. Again, so if the dog's with me, then I experience less anxiety and it's an emotional support animal. A request for that with that documentation should be granted if you confirm that there's a disability related need for the animal. That's really key. Okay, but that being said, certain animals are not traditionally in the home for pleasure rather than other uses. So in the case of unique animals, not your hamsters or gerbils, etc. If you're keeping a unique type of animal that's not commonly kept in household, as described in the last slide, then you have a higher burden, a substantial burden of demonstrating a disability related therapeutic need for that animal, or that specific type of animal. You could still, you could still encourage your client to submit documentation from a healthcare professional confirming the need for this animal, and you still might be able to have that accommodation granted for keeping that animal. But your burden is going to be higher. That's going to be the key thing. Okay. A lot of landlords have policies straight on the lease that say you can't have pets, and there's no exceptions. And that's why I spent fairly significant amount of time, a couple slides back, saying these are not pets. That's really key. And you don't want to use that word. You don't want to say, oh, why can't they have their pet? Well, because pets aren't allowed. But by law, under the Federal Housing Act, under the Minnesota Human Rights Act, under the landlord tenant laws in Minnesota, even though you do not have a right to a pet, you do have a right to an emotional support animal. And so even if the landlord says, I'm sorry, there's a no pet policy, that doesn't apply to service or emotional support animals because they're not considered pets. Okay, this is a very special slide to me because that actually is my dog. Her name's Ada. She is a pet. She's not an emotional support animal, but she's still cute. So I wanted to add her into a slide somewhere here. So this is a new statute. Some of you who have read through Minnesota law and been familiar with it in the past, it's possible that you didn't know there was a change to this, that pet deposits shall not be required by landlords. So when you've requested a reasonable accommodation such that your client can bring their dog or their hamster or their fish, etc., as an emotional support animal into the property, a landlord must not require a tenant with a reasonable accommodation to pay an additional fee, charge, or deposit for the service or support animal. So I've had landlords say, well, we'll let them have it as an accommodation, but they're still going to have to pay an extra pet fee. Well, they can't do that. That's an illegal charge. That being said, you do want to always let your clients know those last three lines of that a tenant remains liable to the landlord for any damage to the premises caused by the service or support animal. Now these things become very, not complicated, but they do, there can be a lot of questions. So I want to address some specific things. So the documentation that can be required. What can a landlord demand in terms of documentation? So this, you'll notice at the top of the slide in the yellow, is from Minnesota Statute 504B.113. That's where a lot of these changes were codified. And I point that out because 504B is not the Minnesota Human Rights Act. It's the Minnesota Landlord Tenant Law. And so, these are specifically going to landlord and tenant relationships. So this is really key though, because I'll just read it. The language is pretty specific and pretty clear. Landlords can request documentation for each animal. I highlighted that because, maybe a person will say that they have, they experience depression and they need an emotional support animal. And so we have two dogs. It's likely that the landlord can say, I need documentation that you need this dog and this dog both individually for a particular disability. And so that's really key. They can request that as part of the RA, the reasonable accommodation request process. For example, a tenant might be required to describe how the animal helps alleviate a physical and or mental disability, or whether the animal is trained to perform a specific task. So I have had clients, and our office has worked with clients who have needed 3 or even 5 animals as support animals. And so reasonable accommodation for each of them. But it's likely the landlord could say, I need individual documentation for each animal.
Tom, I'm going to interrupt and
Yeah.
just give a time check here. It's 4 o'clock. We're scheduled to close at 4:30, but I think we can stay longer if questions persist.
Yep.
I'm going to give you a prize for 5 emotional support animals. I think that's an Olympic record. The best I was ever able to do was 3. I had 1 for anxiety, 1 for alerts for oncoming seizures, and the 3rd one was in training because the first one was getting very old. So you're a great advocate there. Let me suggest we move forward towards the end of your presentation.
Yep.
And then start taking up some questions.
Yep. Sounds good. Thanks, Jay. So I think there's 5 slides left. I'm just going to run through them really fast and just highlight a couple key points that I think you're going to want to know. Again, I've tried to make these as detailed as possible within reason so that you can come back to them and look at them later if you want to pull up that information. If a landlord on this slide, if a landlord does request documentation, the key here is that there are specified in the statute licensed professionals who can provide that documentation. So you're going to want to look through that. You're going to see if the person whose medical diagnosis is being used is falling under these categories. Specifically, this statute also excludes licensed professionals who operate primarily to provide certification for a service or support animal. So some people, you can Google it and you can find, they're not really medical providers at all. They just send you a certificate that says this is a support animal. But that's not going to work under the Minnesota statute. So if you just want to steer your clients away from that. They can also, this is key, landlords can insist that the assistance animals comply with local ordinances. That includes licensure and immunization. I just worked on a case where that was exactly the issue with a client who, they had their dog immunized, but they had no idea they needed to get a license in the city where they were at. And so that may be something you're going to look at. In general, you can, there can't be exclusions to specific types of breeds. Like often pit bulls are excluded in leases. In general, that's not going to fly. However, if it's a wild or exotic animal, that probably would fly. You can read that one yourself. So prohibited conduct, I think it's pretty reasonable. Basically, don't commit fraud or misrepresentation as a tenant. Lastly, I just want to spend just a second here on these last 2 slides, is that sometimes people are requesting reasonable accommodations simply because they're not able to get the full use and enjoyment out of their property that a person without a disability is able to. I've worked with a lot of, multiple clients in that situation. And that can be really rewarding to have them, get use of a service animal or put them in a safer situation. Frequently, however, our clients are coming to us because they've experienced a punitive action from their landlord, like an eviction or the loss of their housing voucher. If that's the case, I just want to request, I want to say just really quickly, number one, you probably want to have them talk to an attorney as quickly as possible. So on this call, I'm with Southern Minnesota Regional Legal Services. Hopefully they could talk to someone here. If we're able to take their call, which is dependent on staffing, the Volunteer Lawyers Network, and we've got another additional resource with lists of people they can call. But you might want to have them contact an attorney right away. And the second thing is you still want them to request a reasonable accommodation right away if it's available. You don't have them wait. Do that immediately, and that can be key. And so you have time to request a reasonable accommodation. It extends until not just talk about eviction or even the filing of an eviction. It extends to the time that the person has actually been removed from the property. And that's really key. Lastly, you can look at this if you have questions about it. I won't go into details on this, but there are time limitations on when you can file complaints and when you can bring legal action. And so be aware of that. If your client says this happened to me 9 months ago, you might want to say, have you filed a complaint yet? Have you looked into a legal action? Because the statute of limitations may run within just a matter of weeks or months or whatever. And you don't want to have anybody's claims or requests or needs denied simply because they brought it too late. Yeah, Jay, I'll wrap up there and we can take in questions, and hopefully I can get my camera back so that I can see whoever we're talking to. But thank you for your time.
All right, so stop sharing your screen, and I think you'll probably get back to the earlier screen. And
Okay. There we go.
One of our attendees just asked the question, please explain the difference between a reasonable accommodation and a reasonable modification. Modifications have to do with the physical plant generally, and accommodations have to do with services, rules, and the like. So a common accommodation or a common modification request would be, for example, if you have mobility restrictions, asking to have grab bars installed in the bathroom where it would be needed. In most cases, that would have to be done at your expense. If it's a publicly subsidized, federally subsidized building, it's a different calculation. They are most likely required to provide those kinds of modifications. A wheelchair ramp would be another modification. Again, if it's private, you would have to pay to have it installed. It has to be done in a way that met license, it couldn't be a ticky-tacky ramp. It'd have to be done according to proper specifications, and you'd have to pay to have it removed at the end. So modifications are physical plant, accommodations are rules and services, and the way they operate. They operate. I hope that answers the questions. Somebody asked about the question about discrimination against persons with public status with regard to public assistance. That's under federal law, or under state law, not federal law. And unfortunately, and the questioner said that he'd seen no Section 8 policies posted. Unfortunately, that's a case that my office litigated some years ago and lost. And while the questioner and I both thought that it made sense that Section 8 voucher holders shouldn't be discriminated against, the Minnesota Court of Appeals disagreed with that. I think there was another question here that I wanted to get back to and bring it to back to Tom. The question is, in Minnesota, do we just use service animal as support animal and not use assistance animal? How does the HUD definition play into this? What's the easiest way to think about this, Tom?
Yeah, good question. Sorry if there was any confusion there. So there is a difference between service animals and support animals. The key is that you can request reasonable accommodations for either of those. They are very different things, just in terms of a service animal is a trained animal, almost always a dog. I do believe that there's sometimes, anyway, there might be a small exception to that, but almost always a dog. And it's certified and it's been trained specifically for certain tasks. You can request an accommodation for that. But the key is you can also request, and it must be granted, a reasonable accommodation for emotional support animals that extends far beyond that limited definition of a service animal. And so there's protections in Minnesota under both the Fair Housing Act and the Minnesota Human Rights Act and landlord tenant law that allows for that. So the key is you can request a reasonable accommodation for both service animals or support animals, and they're not pets.
And so is the answer that it doesn't really matter? You can request for either service or support, but you'll need different kinds of information in order to substantiate the need for the animal.
Yeah, that's true. And so with the support animals, you don't necessarily have to provide it up front, but your landlord can request it. And if they request it and you don't have documentation, it could be denied on that basis. So, I mean, you can request it regardless of documentation, but you're going to be more well served if you have some sort of medical documentation that's providing a direct link between the need for this animal and the disability that you're experiencing.
I'll ask another question. Tom, what are the consequences for a landlord should they not agree to an accommodation or a modification? And what's in it for the tenant or resident if they do file a case?
Yeah, thanks for that, Jay. Yeah, so that kind of gets into some of those that the last slide that they'll be part of the presentation if you want to request that. I don't know where we're going to post that, but so basically what happens is that if a landlord simply refuses an accommodation, and they occasionally do, they say that's, you know, it's an unfair administrative or financial burden, or even though it's you know, doesn't seem like that it is to you, or they say this fundamentally changes the nature of our business, right? So they've denied it. They might do that explicitly. They might do it by simply not responding to your request, and so a week goes by, 2 weeks goes by, several months go by. If they don't respond to your request, I guess practically speaking, the first thing I would say is renew your request, make it again, and say, you know, we demand that this be listened to. You have a legal obligation to respond to this, to engage in an interactive process, to figure out what can be done so that there can be equal use and enjoyment of the premises, whether in public or private space. So that's going to be really key. Short of that, if the landlord still doesn't respond or the landlord's position doesn't change, you can do several different things. One would be you could file a complaint with your city potentially if you're in St. Paul, or I believe in Minneapolis you can do this as well, though I don't practice in Minneapolis.
Yep.
You can file a complaint with the city's human rights board or commission. So they would be able to respond to it. You could also file a complaint with the Minnesota Department of Human Rights, and they would be able to respond to it. You could also file a complaint with HUD, and they would be able to respond to it. Now, each of these processes is going to be pretty similar, but each will be, you know, its own individual process, and so it'll have its own way of meandering a bit. But basically, they're going to investigate that complaint. They're going to see, you know, if there's probable cause that grounded that complaint, and they're going to make some sort of determination as to whether or not your complaint against the landlord basically was grounded in a reasonable basis. If it was, for example, if your complaint was made to HUD, HUD might find, you know, they might make a determination, a final investigative report, that there's a reasonable cause of discrimination. If they do that, they'll issue a determination of a reasonable cause and a charge of discrimination, and you have a decision to make at that point. Do you want to follow that determination up with a case before Housing and Urban Development Administrative Law Judge, so HUD itself can adjudicate these cases, or you can
I got to jump in and
court.
just say, so in the end, at the end, when it's all done, what good can come of it?
Yeah, you can absolutely get a lot of different things. You can get compensation for actual damages. That might include compensation for emotional distress. It might include out-of-pocket expenses that you've paid. You can get injunctive relief, which means an order that whatever you're requesting actually is granted. So if you're requesting that they stop, for example, using certain chemicals, you can get an order from the administrative agency that happens, or from the court. You can get equitable relief, which would mean that, let's say you were denied housing. Let's say you were put out or not allowed to come in the first place. You could have housing be made available to you. And you can get civil penalties. In the case of HUD, you can get civil penalties applied against the landlord. Basically, there's a lot of different remedies that can be applied, including
And the
orders.
worst thing a judge can do is order the landlord to pay your attorney's fees. Because oftentimes the attorney's fees are a lot more expensive than the relief that's given to a that's given to a tenant. I'm going to move on here to a couple of other questions here. In regards to modifications in public or subsidized housing, who's responsible for paying for the modification? Where can I get more information on this? I think that in the resource materials that are posted on the Volunteer Lawyers Network site, there are links to the HUD information on reasonable accommodations and modifications. It's not 100%. You get to have an assisted housing pay, everything. You can't make them build a whole new elevator in a non-elevator building, for example. But I did have a case where it was we were able to get a public contribution to get an automatic door opener, a private contribution to get an automatic door opener, which is a modification that would generally not be required in private housing. Basically, we had a provider that got a lot of public money for this building. They paid half, and a private contributor paid half for the cost of that. It's not 100% on the owner's accounts for everything, but you can look to the HUD on that. So here's another question. I think when I stated this, I didn't state it clearly. Maybe Tom can do it. Could you clarify, for accommodations and modification, it's the tenant who pays for them, right? Does the landlord only have to approve but not pay for it? For example, in my example of a ramp. So let's put it here. Let's put it this way. Tom, I'm your tenant. I broke my back and I can no longer walk. I need a wheelchair ramp into the bottom half of the duplex here. Will you please build me a ramp?
Okay, so if I'm a private landlord, I'm probably going to have to grant that accommodation or that modification, excuse me. But you would be on the hook for that amount of the cost of it. In a public housing situation, if I'm a public housing landlord, then I'd again probably have to accommodate that. It's obviously you'd have to look at the cost, and that's one of those balancing things that I was talking about earlier. And as you said, Jay, if it's something prohibitive, like installing a whole new elevator, that's a different thing than a ramp in this situation. But anyway, in a public housing situation, I, as the landlord, would probably have to foot the cost for that. In general, to the question of for accommodations and modifications, for accommodations, changes to policies and procedures and rules and practices, there's sometimes a cost. Sometimes there's not even a cost, but it's generally more so that the landlord's going to have to figure that out, and they would be able to deny it if there's a prohibitive or undue financial expense. For modifications, it's more likely that the tenant would have to pay for that.
Here's a question. We recently got new management at our HUD financed low-income property, and they're establishing a tenant organization to help keep things on track. What advice do you have to help us be supportive to both management and tenant neighbors who are frustrated by other tenants who are not good neighbors, especially as far as animal care, especially in emotional support animals? Got any wise ideas for that?
To be honest, I was having a hard time following all of that. If you want to take it, go ahead.
Okay,
find the
it's in the Q&A section.
Oh.
We're starting to get a couple in there.
Okay.
Well, first of all, the tenant organizing would really be helped if you contacted Homeline, HOMELINE, which is a tenant organizing group in Bloomington now, I think. But I think this raises another question. How far do my rights extend? People have emotional support animals, and sometimes that creates problems for other tenants. Can you discuss that, Tom?
Yeah, I mean, questions like that are always about balancing pros and cons and figuring out exactly, who's being affected, to what degree are they being affected, is there a way to resolve something? So I guess I would go back to some of that discussion about, thinking about financial cost, cost to neighbors, cost to you. And you have to remember, I think the key to all of these things is to remember that what's really key is the interactive process. And so the landlord does have an obligation, in some way to grant reasonable accommodations and requests for them. But on the other hand, there's also kind of this back and forth where, in a sense, you also have an obligation to work with the landlord to see if there's another way to solve it, to see if there's a less expensive way to solve it, or in this case, a way to resolve an issue that might, alleviate the frustration by the other tenants. And so, in that particular situation, you might want to look at, like, is there times that could be looked at? Is there tools for the dogs that could be looked at? Does there need to be, do you have to agree to training, etc.?
Let's see, I'm looking to see if there's any other questions that we haven't answered. Here's a common situation that came up in the past. People on Social Security don't get their Social Security checks on the first of the month. Some of them don't get them until the 21st of the month, and rent is due by the 5th. And then there's a $25 late payment charge that just adds up and up and up. Is there something that can be done about that?
Yeah, our office has very specifically looked at that issue, has dealt with that specific issue on at least several occasions. And I don't know, I mean, Jay, maybe correct me if I'm wrong. I don't know that there's been a ruling on that specific issue in particular by a court, but I don't think that there has. And our office position has been, this is a classic case of a need for a reasonable accommodation, of explaining, like, if we make this adjustment, it really doesn't cost anything. It may be a slight accounting type of modification, and it should be granted, and it absolutely would allow that person then to the use and enjoyment of the facilities. And so we have requested reasonable accommodations in that exact situation. I know that there have been housing providers that have denied it, and I don't know if there's been a case on point that's resolved it or not.
I think there's a case out of Indiana, it was probably 20 years ago, where I think the landlord was required to pay $100,000 in penalties
Wow.
to the tenant who had requested this, and the landlord had refused to do so. It, you know, the question is it disability related? Yes, you're on Social Security if you're younger because you're disabled. Is it necessary in order to continue to stay there? Yes, because if you're on Social Security and you have to pay $25 a month, pretty soon you're not going to be able to pay your rent, and you'll have to leave. And is it a reasonable thing to do? I think in most instances, the delayed payment by a couple of weeks by one tenant is not an unreasonable thing to have happen. I'm glad to see that one of our attendees found that a landlord was happy to, maybe not happy, but really able to get that to happen. Let me see, any other questions from our audience here? If not, let me move down. Here's another one. This is really true. I have developed really bad arthritis. It's hard for me to walk. Actually, I've been cured, but my condo building has first come, first served parking and has just three disability spots. When I come back from grocery shopping, I often have to leave the food in my car and ask someone else to carry it in for me. I asked the manager if she can help me. She said, you just have to wait till you get a disability spot opens up. I even offered money to buy a close-in spot, but that's not allowed. What can I do? Do I have to sell and move someplace else? What could be done for this person who's gotten old like I have?
Yeah, I mean, to me, that's precisely a case where you're wanting to, again, the way you think through these things are, is there a disability? And I guess that would be a question in this case, but I think it's absolutely reasonable. Is it affecting one or more major aspects of life? And absolutely it is, and it's medically related. You probably get that medical documentation there. You're qualifying as a person with a disability. At that point, finding the nexus. The nexus is it's related to the parking here and the use of the facilities. And so absolutely, that would seem like a case where you're really looking through, how do I make this reasonable accommodation request? And you get the medical documentation. I think it's pretty clear that you at the very least would get to a place where you're engaged in a conversation with the landlord at that point as to is this going to make sense? And I think there's a pretty high likelihood that it would for you in order to get parking that's required for life's activities.
So we're coming up on 4:29. I wanted to just share my screen and illustrate for you some of what you'll find in the resources that are posted at the Volunteer Lawyers Network website. So we see here kind of a blank sample reasonable accommodation or modification request. I won't take time to go through it, but you can copy that out and use it. It has some things to check off, such as whether you might need an interpreter or an advocate with you, how you'd like to be communicated with, authorization to discuss the situation with others, a reminder to keep it quiet, reference to your legal rights and the like. Here's a support. Here's one that's been filled out as a sample. And here's a blank one for supporting for a reasonable accommodation or modification request that could come from a doctor, but might not necessarily have to come from a doctor. It could be from a school counselor, it could be from a minister, but it should come from somebody who knows something about the individual and how it affects their life and how the accommodation may be able to restrict them. And so there's in the document that you can get at the Volunteer Lawyers Network site, you can copy those and see how I filled them out in a particular, yeah, Bridget's just shared them again. You can see these and use those for your own. Let me see, what else did I want to share here? There's this resource list on the in there as well that you can see. You can link through to English, Spanish, Hmong, Somali information from Law Help, which is a legal services program, and then English-based documents from HUD and the Department of Justice. Many of these are ones that Mr. Mueller covered in here. And if you want to get real detail, here are the regulations on it. Here are some information in other languages as well. Minnesota law here, enforcement options and referrals are all covered in that resource list. So I wanted to leave that for everybody to track down at the VLN website so that they can use that. I've already told folks that are working that they'd be excused at 4:30, and probably Mr. Mueller will go back to his other assignments at 4:35 or whenever he gets off this. But I'm willing to stay on if other people wish to engage in some discussions here. I don't know, I may even be able to open it up for verbal responses. Am I able to do that? Or Bridget, are you still there? You open it up for verbal responses here?
If people in the audience want to raise their hand, we can allow them to talk.
Okay. So if you can type in Q&A or chat, or if you'd like to just say something, you're welcome to raise your hand and we'll take your request. Does that mean that Teresa wants to say something here? I see her. Maybe we have covered everything sufficiently. Folks, we had, I think, up to 40 participants at one point this afternoon. I really am pleased that we had so many people stop into this program. So far as I know, it's the first program that first public program that the St. Paul Human Rights and Economic Opportunity Commission has put on for the public of this sort. So it's an experiment. I want to thank Mr. Mueller and Volunteers Lawyers Network staff for helping to get this all together. And we have recorded this. So if you think that your organization could use this, we can certainly make it available to you and may be able to have live people to assist you in that presentation. We still have 21 participants. they're hanging on here. They're waiting for more questions from the audience, or shall I just ask another question from our hypotheticals? What do you think, Thomas?
I think it's up to you. I don't know. I mean, I don't know if there's a way for people to put in the chat what they want. I do need to sign off here in just a couple minutes. So,
All right. Well, there are folks who are saying that they think it's been a good program, and I appreciate that. So thanks for that appreciation. And
I do.
perhaps go
I do
ahead.
want to. I just want to say thanks to you, Jay, Mr. Wilkinson. Thanks for helping spearhead this, and I appreciate the opportunity to share. And thanks to VLN and the Human Rights and Equal Opportunity Commission as well. So it's hopefully this was a valuable use of everyone's time, and I certainly want people to know. I'll put in the chat if people are still here. I'll just put my email, and people are free to feel free to email me if you have any questions or follow up or anything. Feel free to reach out.
Can we get a copy of the PowerPoint to the VLN website?
Yep, I'll get that over.
Okay, so several people have asked for that, so that's great. A wealth of information contained there, and a limited amount of time to cover. You did a great job. More questions here. That's a thank you. You're welcome. I'll just say that unlike just about every area of law, the reasonable accommodations in housing and in other areas provides the kind of tools that I wish we had to undo discrimination in so many fashions. But it's really an affirmative action tool that really brings us closer to equity, or gives us the opportunity to bring us closer to equity. And if you know how to use that, even if you don't feel like you have everything comfortable, just give it a try and call for backup. So, Mr. Mohammed, why don't you just take us out of here this evening?
Yeah, of course. Thank y'all for showing up to this presentation. And without further ado, if you have any more question or information, the emails are in the chat. And if you have anything else, please say that in the chat. But without further ado, thank you, Jay and Thomas, for coming in and answering some of these questions. But yeah, that's it.
Absolutely. Thank you, Abdul Rahman. Mohammed. Okay.